Welcome to Justice Matters. I'm Denise George, Attorney General of the U.S. Virgin Islands. Justice Matters is a program aimed to inform, engage, and empower you with knowledge of Virgin Islands laws and legal issues that affect our everyday lives and our community. We include insightful discussions with my guests so that you can be empowered with knowledge to make a difference in our community. The topic for today is juvenile justice and how it works. While you probably have a general understanding of our criminal justice system through hearing or reading about public arrests, trials, and punishment of adult offenders through our public media, you hear nothing about what's going on in the juvenile justice system involving offenders who are minors. That's primarily because juvenile court cases and proceedings that go on in our family juvenile courts are confidential and not subject to public purview. Youth under the age of 18 who are accused of committing a delinquent or criminal act are typically processed through the juvenile justice system in the family division of the Superior Court, consistent with our local laws, policies, and procedures, specifically pertaining to juvenile justice processes. In some ways, the juvenile justice system is similar to that of the adult criminal justice system, such as arrests, detainments, court hearings, and trials. The juvenile justice process historically operates according to the premise that youth are fundamentally different from adults as to their responsibility for their conduct and their potential for rehabilitation. Over 100 years ago, a separate juvenile justice system was established in the United States with the goal of diverting youthful offenders from the destructive punishments of criminal courts and encouraging rehabilitation based on the individual juvenile's needs. States and territories, including the Virgin Islands, have laws providing for such separate juvenile proceedings that center on prevention and rehabilitation rather than retribution and punishment. And according to youth.gov, these laws recognize that some youths who become involved in the juvenile justice court system may have contributing life difficulties that impact on their emotional, mental, physical, and behavioral well-being, which can probably be resolved with treatment and court intervention. Under VI law and policy, the family division of the Superior Court of the Virgin Islands is the center of our juvenile justice procedure. Title 5, Section 2501 of the Virgin Islands Code establishes the children's policy of the Virgin Islands, which guides our juvenile procedure as to juvenile justice. It states, the policy for children who commit delinquent acts is a balance between treatment and sanctions. Emphasis is placed upon public safety and deterrence. Children should become aware through the imposition of sanctions that delinquent behavior will not be excused. Sanctions will be dispensed in a manner that is appropriate to the seriousness of the offense. So, what is an act of delinquency? Under Virgin Islands law, delinquent act means an act which, if committed by an adult, would constitute a crime under the laws of the Virgin Islands. VI law defines delinquent child as meaning a child who has been adjudicated to have committed a delinquent act. And a person in need of supervision means a child who may not have committed any criminal act, but is deemed in need of intervention and supervision based on certain at-risk behavior. Before the juvenile justice procedure came into play, or before it comes into play, a juvenile must first be referred to the court. Juvenile matters can be referred through the police, law enforcement, parents, schools, the Department of Human Services, probation officers, and victims. To take a closer look into how the juvenile process works in the family division of the Superior Court, joining me now is Assistant Attorney General John Tolud. Attorney Tolud is one of our Assistant Attorneys General in the Family Division of the Department of Justice, representing the government in the Juvenile Family Court Division of the Virgin Islands Superior Court. Welcome to Justice Matters, Attorney Tolud.
Thank you, AG. Good morning.
Good morning. Good morning. And as you know, we're talking about the Juvenile Justice System here, which you have been intimately involved with. Tell the audience, how exactly does it actually work from the beginning? What starts it?
Well, there's a couple different ways in which a juvenile can get into the system. Mm-hmm. You have intervention through the Department of Human Services. Now, the Department of Human Services is an integral partner to this process. I mean, I could not do my job without the dedicated social workers and administrators who were there because they drive the system. We also have cases that could come through the Virgin Islands Police Department, through the Juvenile Bureau, through the various lieutenants and detectives who work the cases once they come in as potentially a criminal matter. The other way that a case can come to the system is through what we call a person in need of supervision. With the PIN, and we call that a PINS.
The PINS, right.
What a PINS is, there are 4 different criteria in which a case can come in through a PIN. It could be a truancy situation. It could be a situation in which someone is abusing illegal drugs or alcohol. It could be a situation where we have a runaway situation. And we could also have a situation where a minor is not observing the reasonable laws, the reasonable rules of their parents' household.
The disobedience.
Disobedience. Not just regular run-of-the-mill disobedience, but ongoing patterns of really disobedient disobedience, if that's a way to put it. What then happens is typically the Department of Human Services, through their intervention and prevention department, will get on board with the social workers, and they will say, for instance, hey, AG Tolud, Assistant Attorney General Tolud, we have a situation where we would like to have the court intervene on behalf of this minor. And what they will do is they'll have the parent swear out an affidavit in which they allege incidents of misconduct consistent with one of those 4 criteria that I just outlined.
And particularly with respect to the PINS, the person in need of supervision, is it still where a parent can actually file a PINS petition as well? Or who can file a PINS petition or request a petition be filed?
Well, that's a very good question, AG. A parent can request a PINS petition. Seldom does that happen where a parent will come directly to our office to do that. What we try to do is to refer them to intervention and prevention services at the Department of Human Services so we can get them connected with a social worker.
Can a parent who is concerned about the behavior of their children file a petition then directly with Department of Human Services? Is that where, if they feel that they need assistance, that they can go?
They would have to first sign and prepare an affidavit in which they put forth the terms of the behavior or misbehavior that is occurring. They swear out that affidavit, then they can either come to our office or they can go to the Department of Human Services, and they would then request that our office files a PINS, and I would then prepare the accusatory instrument, which is basically akin to a criminal complaint, but a lesser version of same. And once we file that with the court will then treat it as a quasi-criminal juvenile matter in which they will schedule the matter on for an advisor of rights and arraignments. They will schedule it for motion practice, for responses to the motions, and they will also schedule it for a juvenile trial. And at the time of that juvenile trial, we will either be prepared to move forward in proving the allegations in the PINs, whether it's truancy, whether it's disobeying the rules of the home, whether it's abusing drugs or alcohol, promiscuity, runaway, and we would be prepared to prove that through testimony, and the same way we would do in a regular juvenile matter. Typically, what happens with the PINs, we would resolve the matter with a consent decree. And basically what the consent decree is, it's an agreement between the parties in which we say that we're going to resolve this matter through non-judicial means, through an agreement. And typically what would be provided for in a consent decree is probationary terms, requiring counseling, requiring completion of a program. We do a lot of focus on education of the youth. We do a lot of focus on focusing on Black history, Virgin Islands history, self-pride and empowerment, and giving back to the community service.
What is the role that Department of Human Services will play in that?
The Department of Human Services, AG, is the engine. We could not do this. We could not benefit the youth the way we do without DHS. Through their social workers, through their administrators, they're the ones that oversee the process. The social workers are the ones who ultimately ensure that the minors are complying with the terms of either their probationary agreements, if they've been adjudicated delinquent, or with the terms, in this case, of the consent decree to make sure that they're following the terms of their probation. DHS, in this particularly on St. Thomas, they run a variety of programs. They provide counseling services. They help set up, if there's a need for mental health related services, they help set those up. If there's a requirement or a need for off-island placement and residential services and that kind of component, DHS spearheads all of this. I could not do my job without DHS.
Is there any specific fundamental aspect of how one is treated if a child comes in from committing a criminal type offense, and how they're treated if it's more of a PINS offense?
Well, from a standpoint of impacting the child, I personally think they're probably the same, because you get before the court, you get before the judge, you're represented by counsel. The youth, I should say, is represented by counsel. You have a prosecuting attorney. It's very formalistic. So whether it's a PINS, which is a formal legal proceeding, or whether it's a matter that comes in through an arrest, it all goes through the same process. I think ultimately it will be resolved the same way. The main differences between a PINS and, let's say, a juvenile arrest. With a juvenile arrest, you would have obviously a young person that is arrested by the Juvenile Bureau. Mm-hmm. They will prepare a probable cause affidavit. Mm-hmm. They would then submit that probable cause affidavit to me. As the prosecutor, I will approve the charges. We will then go before the court within 24, 48 hours of the juvenile's detainment. Mm-hmm. Now, juvenile can either be, depending on the severity of the incident, can either be retained or held at the Juvenile Bureau, or they can be released to their parent. In either event, there's a requirement that they have to, once the probable cause affidavit is signed off on, mm-hmm. the judge will then set that matter up for an advise of rights. Once we do an advise of rights and we determine if there's a need for for bail, depending on the severity of the circumstances. If there's a need that the youth be remanded to the Youth Rehabilitation Center, DHS runs the Youth Rehabilitation Center. A lot of people call it juvenile jail. I think it's a lot more than that.
And why is that? Why do you think it's more than that?
Well, because it provides schooling, it provides counseling. It is more than just a means to detain a purportedly bad individual. It's more than just punishment. It is, I mean, if our jails in this country were maintained the way the Youth Rehabilitation Center is run, I mean, we would probably be in a lot better shape in this country. They have program services, they have access to counseling and therapy, and the faculty, and I don't call, I mean, a lot of people say, oh, they're just guards. It's like, no, they're faculty. They really do a tremendous job in trying to rebuild and redevelop the people, the children who are in their charges.
And that is the YRC, as it's called, right? And located in St. Croix, also. So when you look at how the both treated, whether it's PINs or whether it's however juveniles are treated when they come into the system, what do you see as the focus as far as the desired outcome for the cases, whether we're prosecuting, whether it's for PINs or what the court looks at? What is the general focus?
Well, AG, the general focus will always be intervention, prevention, and if necessary, rehabilitation. Obviously, we try to prevent these situations from happening. Sometimes that's just not possible. That then leads to some sort of interventive means through the courts, through the Department of Human Services, through programs, through social workers, on a day-to-day holistic approach to try to make that connection to the young person, because ultimately we are dealing with children. And that's the one thing that we always have to remember. They might do some very bad things, but they still are ultimately children. And we have jurisdiction typically till the age of 19, when they will officially age out of the system. But whenever I look at a new case or whenever I look at any juvenile matter, this is someone's child. This is a child of the Virgin Islands. And because we are such a small, cohesive community, there are so many things that need to be done or should be done on a day-to-day basis once we have someone within our charge, within our care. Because if we bring them into the system, we are then deciding, are we going to charge them criminally and send them off to the adult system? Or are we going to retain them within the juvenile system and try to intervene into them, try to prevent some bad behavior? And ultimately, if those first two aspects fail, then we try to rehabilitate.
And then as you talk about there's that choice sometimes because of or due to possibly the seriousness of the offense, that a child may be transferred out, and that decision has to be made. Talk about that transfer out to be tried as an adult.
Well, transferring is a tough process because technically most felonies can be subject to a transfer. Now, when you look at the statute under 2708 in Title V, there are 3 different instances in which a case can be transferred. You have a mandatory transfer, and you have a discretionary transfer. Now, with the discretionary transfer, it's a situation in which a minor is charged with a felony, and if they have had previous encounters with the juvenile justice system, that could be an instance in which you petition the court to transfer that matter over to the adult system. There are 2 instances in which that can happen with the discretionary transfer. Ultimately, with those, the Department of Human Services has to prepare a report, and the judge makes the ultimate determination whether that case is going to be bound over or not.
Okay, now what about mandatory transfers?
Mandatory transfers would be the cases that I think, everyone would expect. If there was a serious robbery, a serious gun charge, a homicide, a rape. I mean, certain, and the statute will outline it, certain offenses, we have no discretion whatsoever. Once we file the criminal complaint, within 5 days, we have to make a motion to transfer the case over, and the court will then, either within a few weeks, or I've seen it up to a few months, will then schedule the matter on for a transfer hearing. And what ostensibly happens within that transfer hearing, it's what we, as prosecutors, can call a probable cause hearing.
But what about when we keep them in the juvenile system, and that decision is made in the hopes that they can possibly be saved, that they can possibly be rehabilitated so they don't become adult offenders? How does that work for the juvenile who commits certain offenses, but not to the level where they have to be transferred? What happens, and what kinds of things happen to be able to serve or treat or prevent those kinds of things from happening or turn that juvenile around?
That, I think, is the toughest part of my job, because that's the point. Once we decide to maintain a young person within our system, then it's ostensibly all hands on deck. And what I mean by that is, we become a community, because at that point, we're all there to try to rehabilitate that young person. One of the toughest parts of my job is trying to craft an appropriate plea or an appropriate solution that would hopefully steer that young person where we think they need to be. It is not a one-size-fits-all approach. I have spent many a night agonizing over what to recommend in terms of a plea, or what to recommend in terms of how we want a particular young person in what direction that we want them to go into. And as I mentioned before, but for the assistance and the dedication that I get from the Department of Human Services, social workers, the detectives, VIPD, and everyone else involved, I mean, it would absolutely be impossible. Now, in terms of what we do specifically, a typical plea, you would look at some sort of probationary period. Now, what the probationary period enables us to do, it enables the court basically to keep jurisdiction over the case. It enables them to put certain conditions upon a young person, basically saying, if you do these things within this time period, and if you don't do these things within this time period, then we can either extend the probation, then we can either seek other redress, such as remanding to the to YRC. One of the other things that we always incorporate, depending on the severity of the offense, community service. We will recommend them to various programs. One program that is a stalwart here in the community, which is run by DHS, is the HAWK program, which stands for Higher Achievement, Wisdom, and Knowledge. And that's a program that the Department of Human Services runs through the Intervention Prevention Services program. And it's a program in which it's a mentoring program where the minors learn about history, family history, VI history, U.S. history. It really is a way to try to give them the basic skills that they need. And thank God we have the administrator who runs the HAWK program, Mr. Vaughn Walwyn. I mean, he is absolutely essential to the process. And fortunately, we have someone like him who has the history, who has the experience, and is able to help shepherd these young people in the direction that we ultimately hope that they're going to go into. One of the other things that we do, we can set them up with the Department of Labor, try to require labor services.
So it's all about pulling together, as you said, tailoring something to a program for each individual juvenile to meet their needs.
Absolutely.
That's amazing. Thank you so much. And we're actually running out of time. And I just want to close because I'm going to call you out even publicly that when Attorney Tolud he had actually met him when I became Attorney General, but I know that his experience was in a completely different area of law. And at one point, I told him, because initially he wanted to go back into that area, and when I came to him while he was working in the family court, and I said, okay, good, we have an opening for you to move out and do what it is that he wants to do and what he had experience in, and he tells me, no, I really want to stay here. And it was really amazing. I was like taken aback, and he had gotten so attached to the work and attachment to affecting lives. And that's what the people are doing in family court, the judges, the human services, the social workers, the police, the juvenile bureau of the police department. They work together to impact lives. We may never know which ones turned away and were able to be saved because we won't read about them. So, but the benefits and the accomplishments and everything are just, wonderful. And having had the experience years ago, also working in the family court division, it is perhaps the thing that you don't hear about, why I say unsung heroes, but they perhaps are doing among the most beneficial things to our society, our community, and to our most precious resource, which is our children. So thank you so much for joining us today on Justice Matters. And I thank you, audience, for joining us today. I hope this has been enlightening with respect to the juvenile justice system in the Virgin Islands. And please join us on the next Justice Matters.